Hello guys, and welcome back to another video discussing NFTs and their legal standing. Will NFTs be considered private property? What has the court said about NFTs ownership? If you guys are interested in cryptocurrency, this video is for you. At the end of this video, you will know whether your NFTs will be your cryptographic asset. So let's begin with it. Firstly, will NFTs be considered private property? The High Court of the Republic of Singapore recently issued an interesting decision that sheds light on the nature of non-fungible tokens, NFTs, and the appropriateness of existing laws to such relatively novel technologies by ruling that NFTs may be considered property and thus be the subject of a proprietary injunction. The NFT at the matter in this case is Bored Ape number 2162, which claimant Janesh Rajkumar claims was taken from his possession when he was robbed of all my money and using his ENS domain for identification purposes only. Chef Pierre then advertised the NFT for sale on OpenSea, causing Rajkumar to file an injunction preventing him from dealing with the Bored Ape NFT in any way until the lawsuit is resolved. On October 21st, Judge Lee Siew-kin ruled in favor of Rajkumar and ordered the defendant to stop selling the NFT, which has since been blocked from trade on the NFT exchange OpenSea. The court stated as background that cars, books, wine, and luxury watches are just some few examples of highly sought-after components for collectors, but that for digital nomads, particularly those deeply embedded in the world of the blockchain and cryptocurrencies, NFTs have popped up as a highly sought-after collector's item. Journey to a watch collector. Up next, what has the court said about NFTs ownership? Judge Lee explained that in a prior case, he dealt with the issue of if looted crypto assets, particularly Bitcoin and Ethereum currencies, can give a boost to private property and thus be the subject of a proprietary injunction. He ruled that the plaintiff demonstrated a significant, debatable lawsuit that the plundered cryptocurrency securities have the potential to lead to proprietary rights that could be the subject of a proprietary injunction. To paraphrase Judge Lee, issues arising from the application and implementation of such technological advances will become increasingly common because of the rapid rate at which current technology evolves, raising comparable difficulties, as in the case at hand. In light of this, the judge is of the opinion that whether the framework of the common law can be stretched in a principled sense to accommodate issues using these technologies is the one pressing matter that most lawyers will meet in regards to NFTs and Web3 more generally. Given the recent rulings in the Bored Ape NFT case and the stolen cryptocurrency case, where preliminary injunctions were granted to the plaintiffs and property rights were established in both cases, it appears that the answer is yes. The court's injunction judgment is predicated on the premise that the plaintiff proved he had a proprietary interest in the Bored Ape NFT, which naturally rests on the presumption that the Bored Ape NFT, or NFTs in general, are capable of giving birth to proprietary rights. So, which criteria are used by the judge for property rights? In the case of Raj Kumar versus unknown person, Chef Pierre, 2022, the Honorable Lee Siew-kin considered an order of sale requested over the claimant's Bored Ape NFT. His Honor granted the injunction in an interlocutory ruling, banning the sale of the Bored Ape NFT. This case raised the question of whether non-fungible tokens, NFTs in general, and the Bored Ape NFT in particular, could result in the creation of proprietary rights that could be secured by an injunction. The classic Ainsworth test, which lays forth the concept of a property right, was utilized by Justice Lee Siew-kin to come to a decision regarding whether or not an NFT, which, at its core, is nothing more than a file holding a string of code, may be legally registered as property. His Honor reflected that one could argue that the only thing acquired when purchasing an NFT is information, and that a common objection to NFTs is that they are neither physical assets nor choices in action. This is because those are the only two property categories recognized under common law. When His Honor used the Ainsworth criterion, he came to the decision that crypto assets had to be categorized as choices in action to satisfy the requirements. Up next, what else needs to be considered? The first thing to consider in the criterion is how the asset needs to be defined, and he concluded that this can be accomplished through NFT information. The second need is that the owner must have the ability to be recognized by third parties. Again, this requirement may be checked because the owner is the one who owns the wallet that is connected to the NFT. The third criterion, that the asset has to be capable of supposition by third parties, is satisfied because because the blockchain technology's nature gives the owner an exclusive capability to transfer the NFT to some other party. Therefore, this satisfies the requirement that the asset has to be competent of assumption by third parties. The last criterion emphasizes that the asset must possess some measure of permanency or steadiness in order to be considered valid. His Honor concluded that this is a low standard, given that something like a ticket to a football game can have a brief life, yet is still considered property. Up next, what do NFTs actually consist of? Michael Bacina, a partner at Piper Alderman, stated that the decision, despite the fact that His Honor noted that it is not as sturdy a precedent as a case in which both parties would have been given a chance to provide submissions about the standing of crypto assets, still has significant implications. However, while His Honor made this observation, the decision was made. The court asserts that in most cases, and undoubtedly in the current context, all an NFT includes is a connection to the server, where a true image can be found. In addition, the court notes that even if one is attempting to deal with an on-chain NFT, it is primarily a string of code that involves the code for the image. This information pertains to the question of what NFTs genuinely consist of. Up next, NFTs, information versus property. Which other decisions aided in this regard? When everything is taken into consideration, Judge Lee states that it could be claimed that what is gained when one buys an NFT is essential information. According to the judge, if NFTs are described as information, one could expect to find strong obstacles towards awarding it property status. One might expect to discover serious objections. However, when it comes to crypto assets, such as cryptocurrencies, tokens, and non-fungible tokens, it is possible that it is not totally accurate to classify them as information. In this regard, and citing the decision made by the New Zealand High Court in the case of Rusco versus Cryptopia Limited, in which the court determined that cryptocurrencies, as digital assets, are a type of property under common law, the judge offers his opinion, holding that NFTs, when distilled to the base technology, are not simply simple information, but instead data encoded in a specific manner and securely stored on the blockchain ledger. The court references the Amir Soleimani versus Nifty Gateway LLC case and the May 2022 memorandum order in Hermes International and versus Mason Rothschild. In the Hermes International and versus Mason Rothschild case, Judge Jed Rakoff of the United States District Court for the Southern District of New York rejected Mason Rothschild's motion to dismiss Hermes's claims against him, holding that while there may be an artistic aspect to it. Lastly, how did the judge defend their decision? The judge defends his decision by stating that to characterize NFTs as simple information would overlook the unique connection between the encrypted information as well as the blockchain system, which allows the transmission of this encoded data through one user to the next in a secure and verifiable manner. Citation needed. And while there might be reasons to consider information as property, whether or not to do so depends on the purposes the information is used for rather than on the mere fact that it is information, is a determination that must be made before it can be made. According to Judge Lee, the information at issue in the context of NFTs is a string of computer code at its essential zeros and ones that does not impart any knowledge to the individuals who have read it. Instead, this information simply offers directions to the computer under a framework whereby the owner of the NFT has exclusive authority over its conversion from his wallet to any other wallet. The court ruled in favor of Raj Kumar, consenting to release an injunction. The procedure shed light on how non-fungible tokens, NFTs, are regarded in jurisdictions outside the United States. This was done in light of growing judicial support for implementing property notions to protect digital assets. And this is all from today's video. I hope you guys enjoyed it. Also, if you have any queries, ask us in the comments section below. And remember to subscribe to the channel. We plan to bring more informative videos very soon, so we will meet in another video. Till then, take good care, guys. Thanks for watching. Goodbye.